Welcome to today's broadcast. My name is Sara Simkins, and I'm a Senior Compliance Specialist at Savoy. I'm excited to host this broadcast today and to interview Colleen Patterson, who's the Vice President of Employer Services and Compliance at Savoy. And this is on a topic that has a lot of brokers and employers asking a lot of questions. So today, we're going to discuss how the recent Dobbs v. Jackson court decision impacts employee benefit plans. But before we get started, it's important to note that the information we're going to discuss today should not be construed as legal or tax advice in any way and is meant for informational purposes only. Information changes quickly as guidance is released continuously, so please consult with your attorney or tax advisor for specific information. So, Colleen, can you review what happened and how we got here?
Sure, and thanks for having me today, Sarah. This is definitely a topic that I know we have spent a lot of time on, and as you had mentioned, lots of people are talking about, and all kinds of questions coming from our broker partners. So, what's happened is on Friday, June 24th, the Supreme Court released its decision in this case called Dobbs versus Jackson Women's Health Organization. And the decision found that the United States Constitution does not guarantee a right to abortion access. So what happened is this decision, it effectively overturned the court's prior decisions in two other landmark cases. And those cases were Roe versus Wade and Planned Parenthood versus Casey. The decision resulted in near immediate abortion bans in 13 states. So literally when a decision came down in these 13 states, it became illegal. So in those states, they had previously passed laws stating such bans would go into effect upon a decision by the Supreme Court, making such a prohibition legal. So that's essentially what has been going on and why there's been so much discussion. But in addition to these initial 13 states, 11 more are expected to take similar action, making almost half the states in the country now banning or significantly limiting reproductive health services. And that includes abortion, and some state laws threaten to impose liability on those who may assist an individual in obtaining an abortion. So that's kind of how we got here.
So I know we fielded countless questions about the future of health plan coverage for reproductive health care, the permissibility of travel reimbursements to assist employees in traveling to jurisdictions where abortions remain legal, and other related issues. In this complex legal environment, different questions arise depending on whether a group health plan is fully insured or self-insured, the jurisdictions in which the plan operates, and a variety of other factors. So what does this mean at the state level, since the court's decision sent this back to the states to decide?
This is a great question. So the bottom line is states will now either permit, restrict, or ban abortions. That's what's happened. Because it does vary by state, it's extremely important that employers become aware of the laws in the states where they operate. To be clear, employers want to understand the laws in states where their employees live, not only the laws in which the employer is domiciled. So, as we know, this situation is fluid and it literally is changing by the day. So, Sarah, can you touch on some of the resources that are available about finding out about these state laws so people can gather information?
Sure. First, I want to say that trying to keep up with the daily updates on the status of abortion regulations in each state is a really difficult task. There are some great resources, such as an interactive map by state showing the status of abortion and reproductive services in any given state. Also, the Department of Health and Human Resources, or HHS, has provided current information on abortion laws. So these resources can be found in recent articles that Savoy has released. Colleen, you mentioned previously that when the case was decided, it immediately banned abortion in 13 states, and 11 or so more are likely to do so as well. Can you elaborate on this a little bit?
Sure. Sarah, have you heard the term trigger laws?
Yes, but what exactly does that mean in this context?
So this is a question that we're getting a lot too. So a number of these states have laws on the books that are called trigger laws. And trigger laws are designed to take effect and therefore impose bans or restrictions on abortion when Roe versus Wade is overturned. And as we know, That's essentially what has happened here. In some instances, these trigger laws were enacted when the decision was announced. So that's what happened with those 13 states and these 11 or so other states that are still in some flux of instituting and putting these laws in place. The status of trigger laws is one of the complex issues that's stemming from this Dobbs decision that is expected to garner significant legal action, which may take, honestly, years to resolve. We don't really know what the full impact of this is going to be. Since the U.S. Supreme Court decision on June 24th, temporary injunctions have already been issued in many states with these trigger laws, which temporarily block enforcement of the trigger laws in those states. But similarly, actions are pending in other states. The bottom line is that this is going to continue to be or get more complex as time goes on because it is a state of constant change. So as we had mentioned, there's those 13 states where these trigger laws have already taken effect. There's 11 or so more that are in some stage of that occurring, but these injunctions are being put in place and they're temporary. So it's only going to continue to change again.
So, can group health plans continue to provide coverage for abortion-related expenses?
So this is a really good question. And as I had mentioned, this is a constant state of change. So to answer your question, likely I would say yes, because Dobbs does not prohibit group health plans from covering abortion-related expenses. And I think that's been a little bit of a misconception already with this recent decision. Instead, Dobbs eliminates federal constitutional protections on an individual's choosing to obtain an abortion, meaning that states can outlaw or they can severely curtail access to abortion. Having said that, though, the full answer to this question is absolutely complicated by whether a group health plan is fully insured or self-insured, because as we know, depending on the funding status, fully insured or self-insured, that really is going to impact what is covered by the plan or not.
So, Colleen, can a group health plan cover abortion-related expenses in a state where abortion is legal for someone who resides in a state where abortion is banned?
So this kind of gets back to that prior question, which is about fully insured versus self-insured plans. So a self-insured health plan, they should be able to provide this coverage, assuming that the procedure is performed or the medication that's obtained is in a state where it's legal to do so. But on the other hand, fully insured plans might have a more difficult time providing that coverage because these plans, they are regulated by state insurance laws, which they're not preempted or prevented by ERISA. So presumably, I think that each state banning abortion will seek to prohibit insurance policies that are underwritten in a state from covering abortion, even if the procedure occurs in a state where it is legal. So the fully insured world definitely is a little bit more complex than on the self-insured side. In addition, I also think that some states that are outlawing abortion, they either have or intend to enact statutes that would assess civil or criminal liability for anyone who aids or abets or even assists a resident of that state with procuring an abortion. So constitutionally, these statutes, they haven't really been tested yet. And they are long-standing constitutional laws that suggest that individual states should not be able to enforce laws penalizing out-of-state contact or out-of-state conduct. Nevertheless, it's really possible that a state might use these laws to challenge a group health plan or even an employer that reimburses individuals for the abortion-related cost or related cost for travel to a state where abortion is legal. And that is what's adding another level of complexity here because of this civil or criminal liability exposure. Sara, a lot of our work has really focused on providing information on the governance of group health plans as it relates to ERISA. I know we do this literally every day. So let's talk about what this means, though, in a post-Dobbs era. Does ERISA preempt or does it prevent statutes which prohibit payment of abortion-related costs, as those laws arguably relate to the employee benefit plan?
So, generally, yes. Arguably, statutes implying to prohibit plans from paying for abortion-related services relate to employee benefit plans and are preempted or prevented by ERISA. However, there are some exceptions. So, for example, state insurance laws are not preempted or prevented by ERISA. Neither are state criminal laws of general applicability. So, depending on the circumstances, a court might conclude that a state law criminalizing aiding and abetting behavior in this context is a law of general applicability, and it's not preempted or prevented by ERISA.
I think this is a great point because this is really the unknown risk that could expose the plan sponsor and plan fiduciaries to potential criminal penalties on the basis that a group health plan violates the law by covering an out of state legal abortion. On the other hand, taking into account the purposes of ERISA preemption in the first place, a court could conclude that these types of aiding and abetting laws targeted to abortion are not laws of general applicability. So the bottom line is it's really difficult to predict how a court might rule on this issue since Roe versus Wade predates ERISA. And that's really important to recognize that ERISA was put into place after the Roe v. Wade decision. So there are no test cases on the books as to whether pre-Roe state abortion laws were preempted or could be prevented by ERISA. So plan sponsors, they really should carefully evaluate the risks of covering reproductive care and related travel expenses based on the state law that they are concerned with.
So let's shift gears a little bit and talk about offering travel benefits to access reproductive care. Colleen, can a group health plan pay for expenses for an out of state resident to travel to access reproductive care, which includes abortion?
Yes, and the reason for that is because these plans are not new and they've been around for a long time. A group health plan, they may cover travel expenses incurred in connection with assessing health care, including reproductive care. And travel expenses, and when I'm saying travel expenses, that's in the context of transportation and lodging, or medical expenses eligible for reimbursement from a group health plan. Of course, this is going to be subject to the caveats that we've talked about before, where there is risk to the group health plan, and those risks are by state civil and criminal statutes penalizing assistance with procuring reproductive care. So the account has been around for a while as far as allowing to do this, but there's this added level of concern, which is this whole civil and criminal statute issue.
So, are there any limits on the amount of travel expenses that a group health plan may reimburse as a tax-free benefit?
Yes, and remember, these aren't new plans. So travel expenses necessary to access medical care, including abortion and other reproductive care, they're reimbursable as tax-free medical expenses up to certain dollar limits, and the IRS sets what those limits are. Examples of these kinds of programs, they could include health reimbursement arrangements, so that's an HRA. It could be a health flexible spending account, so that's a health FSA. Also could be accepted benefit employee assistance plans, so that's what we call accepted benefit EAPs. And of course, health savings accounts, and those are HRAs. Tax-free medical expenses could include things like mileage, tickets for planes or trains, buses, and lodging expenses. But the travel must be primarily for and essential to medical care and not for vacation or any kind of recreation. So what we're really talking about here is Section 213 of the Internal Revenue Code. And it's this section of the code that outlines what is permissible as an eligible medical expense and certainly what is not.
So, you mentioned tax-free reimbursement, but what about the flip side? Can a group health plan reimburse travel expenses in excess of the applicable IRS limits?
So this is a question that comes up all the time, and I think it's a really good question because people are being creative, which is also it's a good thing. But I think the answer is going to depend on whether the plan is fully insured or self-insured. So fully insured plans, as we talked about a few minutes ago, they are unlikely to permit reimbursement of travel benefits expenses in excess of the IRS limits. Plan sponsors of self-insured plans, though, they have a little bit more flexibility to reimburse access expenses under a group health plan. Although it's important to note those access expenses, they're going to be considered taxable and they're going to be subject to whatever the normal withholding would be. In either case, though, reimbursements for related travel expenses that exceed the IRS amounts are considered gross income and wages, and they're going to be subject to regular income and payroll taxes. I think the other thing that's important to note too is that the plan's third-party claims administrator, they're going to have to agree to process the reimbursements in excess of the IRS limits. So for a self-insured multi-employer health plan that utilizes a voluntary employee beneficiary association, and that's what we call a VEBA, so that's a VEBA. And what we're really talking about is a trust. So the trust that's being used to pay health plan expenses, tax and legal counsel is absolutely going to have to be consulted, because they really should analyze whether the VEBA's reimbursement of travel expenses in excess of the IRS limits is going to jeopardize the tax-exempt nature of the trust. So even if you're self-insured, although you have more flexibility, if you're operating in this VEBA world, you've got a few other things that you have to think about. So Sara, would you address whether or not plan sponsors have to consider mental health parity concerns when adding travel benefits to access reproductive care?
Yes, absolutely. So the Mental Health Parity and Addiction Equity Act, which is also sometimes referred to as the Parity Act, requires that group health plans offering mental health or substance use disorder benefits provide them in parity with the medical and surgical benefits covered under the plan. If a plan sponsor chooses to provide travel benefits only for reproductive care and not for mental health or substance use disorder services, this has to be carefully reviewed to ensure that it's done consistently with the Parity Act. So we've touched on several federal laws so far, such as ERISA, Section 125, Section 213, and the Mental Health Parity Act. This next question now touches on the realm of the Affordable Care Act, or ACA. Can travel benefits be offered under a high deductible health plan?
This is a good question too, and you're absolutely right, Sara. And this, I think, speaks to the complexity of this topic, because there's so many federal laws that have to be considered here. So to answer your question about travel benefits and can it be offered under a high deductible health plan, the answer to that is yes. However, what we have to think about as it relates to the ACA is first dollar coverage of travel expenses for reproductive care would not be possible under a high deductible health plan until the individual satisfies the plan's annual deductible. Now, on the flip side of that, an individual covered by a high deductible health plan would be able to withdraw funds from their health savings account, so their HSA, to reimburse travel expenses to access reproductive coverage, and assuming, and of course, that that is consistent with the IRS limits on eligible travel benefits. So Sara, let's talk a little bit about alternative approaches, such as offering a travel plan or travel benefits outside of the group health plan. So can you address whether employers can just pay as you go outside of a group health plan, and or could they offer an ad hoc taxable reimbursement of travel expenses to access reproductive care?
So there are a few potential legal issues associated with this approach that require employers to carefully evaluate whether the risks outweigh the rewards. There are significant privacy concerns, including Hipaa and state law, when an employer holds information about employee reproductive care decisions. Similarly, retaining this type of information about an employee may inadvertently expose an employer to claims under Title VII, which refers to employment discrimination, if an adverse employment action is taken against an employee who obtained an abortion or even contemplated having an abortion. So this pay-as-you-go approach also might complicate an employer's ability to assert ERISA's preemption if the employer's reimbursement is challenged under a civil state law or criminal law that prohibits aiding and abetting or otherwise assisting individuals in obtaining an abortion.
So that's good information too. So let's pause here for a minute and let's address ERISA preemption. And to be clear, as Sara had mentioned in the very beginning, all of the information we're providing is, of course, for informational purposes, and you certainly want to seek legal counsel around all of this. But this comes up all the time for Sara and I, which is what is ERISA preemption, and can you just kind of break it down for me? So, as I've said, we've talked about this, we've used this term several times throughout our conversation today. However, I want to define it more clearly in the context that we are using this term. So, in the context of ERISA, to preempt something is to take its place because of priority. So, this means that ERISA has a higher priority than similar or directly conflicting state laws. So ERISA takes the place of those laws, even if the law was written after ERISA. Now, ERISA essentially helps strike a balance between the plan and its participants. That's why ERISA is even here. And that's just a very broad definition of its purpose. The complexity this poses, though, with the Dobbs decision and whether or not ERISA preemption will provide any protection for plan sponsors may take years to determine. And the reason for that is because the facts and the circumstances of these cases is going to vary greatly, making determination even more difficult. And the reason it's going to vary greatly is because we talked earlier about how, at this point, almost half the country has some type of legal activity that has changed or is changing around this topic. So it's going to be quite some time before we hear any kind of guidance on how this whole ERISA preemption or protection is going to impact or not plan sponsors. So stay tuned.
That's a really good point, Colleen. So even with these pay-as-you-go arrangements, it's technically an ERISA-covered group health plan because an employer is reimbursing employee medical expenses. So this means a court might view the ERISA preemption defense as pretty weak if the employer didn't document the arrangement as a formalized group health plan, and if they didn't comply with the generally applicable ERISA mandates that apply to group health plans.
That's a great point too. And also the arrangement itself could expose the plan sponsor and fiduciaries to penalties under ERISA as a non-compliant group health plan. And examples of that would be failure to comply with the ACA mandates or failure to comply with COBRA, maybe failure to comply with Form 5500 reporting. And I feel like there's a potential of a lot of failures. So there's a huge compliance aspect here when you're talking about these plans. So employers should also consider other related issues that's posed by using a pay-as-you-go approach. So an example of that would be if someone is covered by a high deductible health plan, first dollar reimbursement of travel expenses for the medical benefits would impact the individual's eligibility to make health savings account, meaning HSA contributions. Also, there's taxable reimbursements to employees under a pay-as-you-go approach, and that could be viewed as an additional compensation for purposes of other benefit plans in which they participate. So that would be something like a qualified retirement plan. So there's a lot to think about in that pay-as-you-go world as it relates to all of these federal mandates that we've touched on, and there's certainly more to come. Sara, what about creating a separate health reimbursement arrangement or an HRA solely for reimbursing travel expenses to access reproductive care? Can it be done?
Well, potentially. Health reimbursement arrangements, or HRAs, are group health plans, meaning they can reimburse medical expenses such as travel expenses to access reproductive care. Because they are group health plans, HRAs are subject to the Patient Protection and Affordable Care Act, or ACA, market reforms. So to avoid tripping over the ACA rules that would otherwise apply to group health plans, such as first dollar coverage or preventive services, the HRA must be structured as an integrated HRA or an accepted benefit HRA. To satisfy the requirements for an integrated HRA, the HRA generally must be offered in connection with either group health coverage that does not consist solely of accepted benefits, and the individual must be enrolled in the group health coverage through either the employer or through another plan that meets the ACA's minimum value standard. Also, HRAs generally are subject to the ERISA's reporting and disclosure rules, as well as COBRA, among a few other requirements. In comparison, there are fewer regulatory requirements applicable to an accepted benefit HRA, including the elimination of the requirement that the individual is enrolled in other group coverage which provides minimum value. However, an accepted benefit HRA currently limits reimbursements to $1,800 per year, which is then indexed for inflation. So that may not meet the plan sponsor's objectives. Colleen, can travel benefits for abortion be offered through an employee assistance plan, maybe?
So this is another good question, and I think the answer is yes, but depending on how it's structured, an employee assistance plan or an EAP, it may be a group health plan that's governed by ERISA and subject to ACA rules and other requirements potentially that we've already discussed. An EAP, it must be structured as an accepted benefit to avoid various compliance requirements. So you really want to ensure that an individual's eligibility for the EAP benefits does not interfere with eligibility to make HSA contributions, if it's applicable. And we've touched on that just a couple of minutes ago. Another important consideration, though, is the EAP may not provide significant benefits in the nature of medical care or even treatment. So this, of course, it's kind of subjective, and there's a subjective test that will require a careful review of all the benefits that are offered under the EAP in the aggregate. So all of the things that the EAP would be covering, not just this one particular service. So some employers, they may actually decide that adding a travel benefit to an existing EAP may actually kind of tip the scales towards the EAP providing significant medical care or treatment benefits, especially if the dollar amounts that would be reimbursed under the EAP are substantial. So I'm going to pause here for a second because as we've been talking about all of these different types of accounts or arrangements, and again, that's the HRA, so health reimbursement arrangement, a HSA, we're certainly touched on EAPs. I wanted to take a moment and talk a little bit about vendors that may be providing these services to plan sponsors today. And what's important here is that what we've been learning is the third-party administrator, or the TPA, and I'm using that term in context as the TPA that is administering these type of plans, the HRAs, the HSAs, the EAPs that are out there. What we are learning is that several of these vendors are requiring additional substantiation for services in states that they know that obtaining these types of services may be a bit of an issue if it is for somebody who is a resident of another state and they're going to a state where these services are legal. And the other thing that we're also learning is that several of these TPAs, the way that they're reporting is to the plan sponsor, which would be the employer, also varies a little bit, meaning some TPAs provide a little bit more information on the reports showing the substantiation of the claims that are being reimbursed versus others are not as detailed in their information. So that's important because of the Hipaa component. The other thing that we wanted to mention, because we've been seeing this with these third parties as well, is that several of them are updating their contracts. And as a result, this may be something that a plan sponsor might want to take an opportunity to review or do a vendor analysis, because maybe the plan sponsor or the employer does want a stricter approach or may not. So it's just an opportunity to review that. But the one thing that I would say is that we definitely want to caution and say, buyer beware from the perspective of it really is important that even if you have an existing TPA in place because you're already providing an HRA or an HSA or even an EAP and you're considering some of these other programs or some of these other things that we've talked about today, you definitely want to make sure that you seek your advice from your tax or legal counsel for the states that you may have some concern as it relates to your current vendor. And you want to work very closely with them to just ensure that everybody understands from a compliance perspective how these particular services would be reimbursed in those states that the employer may have a concern with. So another area that we've looked into is the impact for infertility coverage. So specifically, Sara, does the Dobbs impact infertility benefit coverage under a group health plan?
Well, I feel like I've been saying this a lot today, but my answer is potentially. Termination of a fertilized egg or embryo occurs relatively frequently at the conclusion of in vitro fertilization or IVF treatment. So this could mean that IVF coverage may no longer be available in a state that outlaws abortion, which in turn might require consideration of the same travel benefit analysis that we've been discussing in the context of reproductive care. This may also cause complications for individuals who are currently undergoing IVF treatment in a state where the procedure is now illegal. So, Colleen, we're getting down to the home stretch for today. Would you address whether or not the federal agencies that regulate benefit plans will maybe issue some guidance for us?
Sure, and I gotta say, I sure hope so because this is definitely a daily changing topic. So what we've already seen, though, is there has been some guidance or even reminders of existing regulations from different agencies. I remember seeing just a few weeks ago, it was Friday, July 8th, that President Biden had signed an executive order, and that executive order was directing federal agencies to take some incremental steps that's within their power to determine how to preserve abortion and reproductive health services. And that also included ensuring the availability of emergency contraceptive medications and also providing legal protection for out-of-state patients and abortion providers. He did note, though, that it would take political and legislative change to restore the rights that were removed when the Supreme Court decision in the Dobbs case essentially did overturn Roe versus Wade. But the other thing that we've also seen that has come out recently is in response to concerns about the impact on healthcare privacy as a result of overturning Roe versus Wade, HHS, they actually released clarifying guidance regarding HIPAA privacy rules and clarifying patients' rights and ACA requirements for health plans and providers. And the reason for that is because, as I was just mentioning, these TPAs, and those are the vendors that are administering the HRAs, et cetera, that has to have access to this information in order to substantiate. HHS was reminding everybody of the privacy rules and patient rights because this information may be coming available more than it was before. There is one other thing, though, that we did recently see some guidance or at least an announcement from, and that was from CMS. CMS had released a statement indicating that they intended to take all actions within the scope of its authority to be able to ensure individuals can retain reproductive autonomy. So the consensus really is that the potential agency relief from the DOL, the IRS, and HHS, there's a couple of areas that we've been talking about that we see that group health plans might get some clarification on. And that would be something like the classification of travel benefits to access reproductive care as a non-disqualifying coverage for purposes of permitting first dollar reimbursement of travel expenses. So we do think that there's going to be likely some information coming out about that because, again, this is the first time that any of this has to have been looked at because a lot of these federal laws that we're talking about, they were enacted after the Roe v. Wade decision was made all those years ago. Another area that we would expect that there could be some potential agency guidance on would be offering a special enrollment period that would permit individuals to add or switch group health plan coverage mid-year to join a group health plan offering travel benefits to access reproductive care. So that would be under the context of clarifying that individuals would be able to change their coverage despite the IRS cafeteria plan rules that might otherwise prohibit that type of a mid-year change. So I think the bottom line here is that stay tuned because this is something that I think the agencies as a whole over a period of time will absolutely be addressing and providing some clarifying information.
Wow, so that's a lot of really great information. Thank you, Colleen, for putting this together and kind of educating everyone. I know right now it's really in a state of flux, and it seems like everything's up in the air, and we just really don't know. Especially when it comes to every different state now seems to have something different going on.
You are absolutely right. And thanks, Sarah, too, for helping me through all this content. It has been a labor of love, to say the least.
Okay, so we're continuing to research information, and we're going to share what we learn as more information becomes available. So as with any new change in legislation, this will take time to fully understand all the potential aspects of the impact of this decision. Our team has released several articles on this topic, which can be found in the news section of our website. And as always, should you have any questions, please reach out to your dedicated Savoy team and continue to use all of the resources available on our website at savoyassociates.com. From all of us at Savoy, stay healthy and safe. Thank you for joining us.